Hi, good morning, everyone. I'm Lisa Stiver, and John Woolley is with us as well. John, will you give us a quick hi? And I note that we have, oh, there we go. We have 10 of your folks, 13 already, 13 who are already in. So I thought we would begin, and then others can join if you're expecting. I forgot, Denny, I should have asked you how many we were expecting, but I see 13 now. So what we'll be talking about today is the presentation that I believe at least one of you, if not more than one of you, heard for the Winnipeg Construction Association. We've altered it a little bit as well. We were provided some questions from your team that you would like us to address. So we've worked some of it into our presentation, and then we'd like to leave time at the end at the end of our slides, where we will then answer your questions specifically and give you all an opportunity to ask questions. So what we're going to do is I will be speaking first, then John will be speaking. Everybody is muted at that time. If you just wanted to note some of your questions then what we'll do is we'll go to the questions that have been provided to us, and we'll go through those as well. And then at that point, I think I'll unmute everybody, or I could even unmute everybody at that point, and you could just mute yourself then if you're not intending to ask any questions, and everybody can then ask questions as they choose. So I will begin now, and any other questions if you have, if there's something you'd like us to know about during the presentation, if you look on the right side of the screen, there's a little triangle next to the box that says questions. If you open that, you can write down something there that I'll be looking at when John is speaking, and so that we can address anything that comes up during the presentation as well. So I'll get started here. So the first part of, this is just our bios. Sorry, this is our bios for these presentations. Most of you have met one or both of us before. So I'm Lisa, and I work in the corporate commercial world, and John is one of our partners in the litigation world. So COVID-19 has raised or brought to light, I'd say, a clause that a lot of people consider boilerplate, or a lot of clients just gloss over. And I have to admit, it's not something that in my usual drafting I pay a lot of attention to, but it's come to light now and is at the forefront of a lot of people's contractual discussions, the concept of force majeure. So most commercial agreements provide for parties to be excused from their contractual obligations in the event of serious unforeseen circumstances. This is called force majeure. A force majeure clause generally discharges a contracting party when a supervening event that is beyond the control of either party makes performance of that party's obligations impossible. While force majeure clauses differ in how they're constructed, the common thread among them is that it must be something unexpected and beyond foresight and skill that has now happened. So when can you get out of a contract due to something like the pandemic we have here? Well, there are three things that you have to consider. So whether or not you can rely on your force majeure clause depends on the nature of the contract and the obligations under the contract, and how it actually has been affected by COVID. So there are three key factors that determine when a party can rely on a force majeure clause to relieve themselves of any contractual obligations. So first of all, does COVID-19 fall within force majeure in your contract? This depends. I know this sounds like a very lawyerly response, but this depends on the clause's specific wording within the contract. So in this case, actually, this is not the most significant factor for this particular event. I don't think there's any issue anymore that people would be able to take up with the fact that COVID-19 is a force majeure event. But perhaps now we go back, we're talking January, perhaps early February, you would have to look at the exact wording of your clause to see if COVID-19 qualified as a force majeure event. The words used in the force majeure event clause are words like epidemic, illness, disease, pandemic. The word pandemic, if you happen to have that in your clause, well then COVID-19 falls squarely within that. If your clause does not have specific wording like disease, pandemic, outbreak, almost all force majeure clauses have a catch-all phrase, something like acts of God or circumstances beyond a party's reasonable control. The key for these clauses are that the courts construe them restrictively. So they're interpreted quite narrowly. The court will not broaden your force majeure clause. So your event must fall into one of the words, the descriptive words, or then the act of God or something that's unforeseen. And this is the key. It must be unforeseen. Of course, as you would probably imagine, what is unforeseen changes at certain times. So particularly with this pandemic, something that might have been unforeseen earlier is now not unforeseen. So it does change the nature of when the force majeure clause can be triggered based on the unforeseeability of the event. So we've established number one, it does fall within the contract. Number two, has COVID-19 sufficiently impacted my obligations? So you have to look at the level of impact. Most force majeure clauses will set out some type of threshold, like they'll say it prevents or it renders impossible the performance of the obligation. So whether the triggering event, in this case COVID-19, meets this threshold depends on the factual circumstances at the time, and of course what the nature of the obligation is. The key is the level of impact must be rendered impossible or prohibits. It can't just be a mere inconvenience or a delay or something else, like an increase in pricing because of a delay or because you have to reroute the goods. That does not then render the performance impossible. Another thing you have to look at when you're determining whether or not it's sufficiently impacted your obligations is it has to have a direct impact. So it needs to have a direct impact on your obligation. What would be considered an indirect impact would be, as I just mentioned, pricing fluctuations or revisions to workflow methods to enable the performance of the obligation. That then is not a direct impact. One example I like to give is, for example, if you're a manufacturer, you're dealing with a supplier here who manufactures goods and they have a plant in Quebec. And in Quebec, where the outbreak is much more severe, their plant perhaps is closed. That could be considered a direct impact on their ability to supply the goods, unless they have a plant in, let's say, Alberta. In Alberta, the province has not been as hard hit. There is not a lockdown on as many industries. If they were able to then source their goods out of Alberta, it would then not be considered a direct impact on their obligations. The third thing you have to look at once you've looked at those first 2 points is mitigation. So this is a legal concept where you look at, has the relying party taken sufficient steps to avoid and mitigate the impact, as in lessen the impact of the COVID-19 event on your ability to perform your obligations. So a party seeking to lie on a force majeure clause must take steps to mitigate what is then the foreseeable impact of force majeure. So even the COVID-19 event itself is unforeseeable. Once it happens, if you can then determine and you can foresee further damages down the road, further inability to perform your obligations, that is when you have to take reasonable steps to prevent those foreseeable things from occurring. Some force majeure clauses actually require that you mitigate, but even where a contract is silent on the need for mitigation, courts will be reluctant to recognize force majeure events if it shows that the party did nothing to lessen the impacts of the event. So what does that mean from a business standpoint? From an organizational standpoint, if you are the party seeking to rely on the force majeure clause, you have to document what you did when the event occurred, how you mitigated or lessened the effect of it on your obligations. If you're on the receiving end of a force majeure clause, if another party has told you pursuant to force majeure they're unable to fulfill the requirements under the contract with you, you will then ask for evidence of this party's mitigation, what they did. Courts will, as I said, some contracts say you have to provide it, but courts are very hesitant to say just without any evidence, yeah, for sure, they rightly relied on the force majeure clause. So what does mitigation mean, and when in the context of COVID-19 would this come into play? For example, as you all know, our municipal and our provincial protocols changed a lot over the weeks. They even changed on a daily basis. So if you were working in a manufacturing plant again, or a plant where you had a large workforce, if you didn't take measures at the outset to social distance and have PPE for your staff, and then as a result there was an outbreak in your workplace and you had to shut down, that would not be considered mitigating, because on a daily basis the province was issuing recommendations, guidelines, protocols. On the other hand, if you did abide by all of those and there still was a direct impact on your business and you were unable to fulfill your obligations, then you could show the evidence of you complying, following best practices, and still you're unable to perform. So in summary, these are the three things you need to have a look at in order to exercise a force majeure clause. Review the specific definition in your contract. Make sure that it, and in this case, as I said, this one is very easy for COVID-19 to meet. Number two, what was the effect of COVID-19 on your obligations in the contract? Inconvenience is not enough. It must be impossibility of performance. And then if you now cannot perform, what did you do to lessen the impact? You have to show that you took steps to make sure that you could, to the greatest degree possible, lessen the impact on your contractual obligations. So that's force majeure. Very quickly, I just want to cover off that you also cannot just look at force majeure in isolation of the rest of your contract. You must then look at other provisions in your contract to make sure that they as well are either not affected by it or how they interplay with the force majeure clause. Notice, almost all contracts have a notice requirement. In some cases, if you plan to exercise a force majeure, you must abide by certain notice requirements. You must do that in order to effectively use the force majeure provisions. As well, there's dispute resolution provisions in a lot of contracts. Some force majeure provisions do then refer you to the dispute resolution provisions of your contract, even if it doesn't, and there is a dispute about whether or not you properly exercised the force majeure or whether you on the receiving end decided that you didn't think the party was doing this properly, you can usually invoke the dispute resolution clause in your contract, so you'll want to take a look at that. Liability clauses. Well, the idea of force majeure is that you are able to then get out of your contractual obligations without liability. I mean, I think that goes without saying, although I probably should have said it at the beginning. The idea is that you avoid liability. However, not in every case. So you want to look at your liability clauses in your provisions in your agreement to ensure that by relying on force majeure, you weren't either walking right into some type of predetermined penalty, or that there was not specific liability that arose in addition to or because of your force majeure provisions. And then lastly, termination. This is something that comes up, well, it's come up several times now in the last few weeks. I was going to say it comes up rarely, but in the last little while it's come up often. Force majeure is not generally termination. It is not. It is supposed to be a temporary suspension of your obligations under the contract. It is supposed to preserve the contract. However, in some cases, you have to look at your termination provision. In some cases, it does speak to force majeure for beyond a period of time would then lead to termination of the contract. You would want to make sure that you were aware of that before you exercised your force majeure rights. Now, let's say you have a contract that does not have a force majeure clause, and a lot of them don't. Unfortunately, you cannot imply a force majeure clause into a contract, and the courts won't do that as well. There must be express language. So in these circumstances, parties instead may rely on a common law doctrine of frustration. And in Manitoba, as well as the other provinces, we have a piece of legislation, the Frustrated Contracts Act. This act applies to contracts made in Manitoba that have become impossible to perform with some limited exclusions, very, very limited exclusions. So frustration occurs where a situation has arisen where the parties have no provision in the contract and the performance becomes fundamentally different. So the threshold for a force majeure is almost the same as the threshold for frustration. There must be a supervening event, something that was unforeseen as well. It had not been contemplated and there's no force majeure clause to deal with it. And it renders the performance of the obligations impossible. And again, it's not enough that the contract maybe becomes more onerous or more difficult, but it must be impossible to perform. As with force majeure, the party who's relying on it must establish these elements. And the difference with frustration is it is a termination of the contract. So a force majeure clause may provide temporary suspension or deferral of obligations, whereas frustration means actually the contract is now terminated. So with both force majeure and frustration, you will want to make sure that if you plan to use these provisions, that you have to take into account how it affects the business that you're in, how it affects your relationship with the other party, because these are significant remedies. So what we try to encourage clients to do instead of first going to either of these remedies is to try to negotiate with the other party and see if there's a way that you can come to an agreeable solution with both parties, because force majeure can down the road it may not absolve you entirely of liability, or you can't be sure of it. And for frustration, it does end the relationship between the parties. So with that, I am going to move on to John, and then we'll take some questions afterward.
Thanks, Lisa. My portion of the presentation is a bit more limited and a bit more focused just on what COVID-19 has done to some of the procedural elements around the Builders Liens Act and claims in court, just to keep you up to date as to what's going on there, and hopefully to dispel maybe some misinformation that you might have heard either through online sources or news articles or in other places. So the first, the overall message I have to tell you with respect to builders liens is that the more things change, the more they stay the same. In Manitoba, although society has been fundamentally altered because of this, very little has changed under the lien legislation. So the first thing to know is that unlike other jurisdictions, there were no suspension of limitation periods in Manitoba, and that's very important with respect to builders liens. Because as you all know, liens are something that are extremely time sensitive. So in Ontario and in BC and some other jurisdictions, there was a suspension of limitation periods that played havoc with things like lien registration periods, holdback releases, and so on. But in Manitoba, all time periods under the Builders Liens Act are still in force. So that means liens still need to be filed in accordance with the Act. So 40 days after substantial performance or abandonment or last supply to site, that 40-day period is still very much in play. Because that 40-day period for liens is much in play, so is the holdback release time, and that's something that will be much more applicable, I think, to the WRHA. Is we're still dealing with holdback releases on 40 days from substantial performance. One of the major trends that we're seeing, and indeed one of the things that we're encouraging, is that for lengthy projects, for subcontractors, they really should be asking for certificates of substantial performance of their subcontracts in order to get cash, in order to get holdback releases earlier on and cash to flow. So just to provide you with an example for this, if there's a project underway where it's a 2 or 3 year project ultimately to build a building, and the excavation contractor is done, we don't want to see that holdback for the excavation contractor being held up until substantial performance of the project. There is a process under the Builders Liens Act by which the subcontractor can apply to the contractor, and the contractor can in turn apply to the owner to say, look, this subcontractor has substantially performed its work. We want to reduce the overall holdback by the amount that is owed, the 7.5% that is owed to this subcontractor, because they're done. There's no reason why that shouldn't happen, and from industry-wide perspective, that will improve everyone's cash flow. So where possible, we're encouraging everybody to take advantage of things like that so that they can continue to have cash flow. One of the other trends that we're seeing, incidentally, with respect to holdback release is some of the larger projects that have that still have a vast sort of timeline. There's been an increased pressure upon some contractors who are really feeling the brunt of cash flow issues to phase out projects now. So where you may have had a project go for a 3-year period, they're now going to break that down, or they're going to try and break that down, that one contract, into different phases, essentially 3 separate contracts, which would allow for holdback releases at earlier dates. So that 7.5% isn't tied up for that length of a 3-year period. That is a bit more of a tricky issue to deal with. And there's certainly some pluses and minuses on it. But it is an option that is out there, that if you are looking to help out contractors, or you're worried that you might have an issue with your contractor if they don't get some cash flow, that is an option that can be had. But that's something that has to be dealt with very carefully, particularly if you have a contract in place already. If you're thinking about tendering a contract, that is going to go out in the next short while, and it is a longer project. You may think about, prospectively at least, phasing it out so that you look at it and you may have one tender for different phases of the project. Those phases all have separate contracts so that you can trigger holdback releases earlier and earlier releases of cash flow. You're not filing liens, so that's not really a practical concern with you, but the issue with the Land Titles Office is that there's now a 3-day turnaround time to file liens. So again, that's not applicable, I think, to anybody on this call, but it's maybe just something that you would note. Maybe we'll just flip over to the next slide. In terms of the courthouse itself, what is going on there? Again, limitation periods, including court guidelines, have not been suspended, and court rules. So in terms of the way that litigation is proceeding along, there have been delays. Definitely, there have been cancellations of pretrial hearings, judicially assisted dispute resolutions, and so on. Those types of conferences, some were canceled, but they're now open for rescheduling. And the good news is that hearings from May 25th to June 30th are going to proceed as scheduled. So the courts pretty much as of May 25th are going to be, I won't say back to normal, but very much running a full schedule. So there's been a relatively small impact on the courthouse with respect to COVID-19 issues. Private arbitrations, private mediations, those are being driven largely by the parties, so and the arbitrators and mediators, and that is a mixed bag. Some are proceeding ahead like nothing is happening, or like nothing happened. That is to say, they're keeping their schedules and so on, and everybody is going ahead. Much more common, I think, is you're having mediators who are refusing to meet in person, and arbitrators who are refusing to meet in person, wanting everything to go over virtual calls. There's been a real slowdown on discovery proceedings and document disclosure proceedings because of just difficulties, with people out of offices and so on, finding documents and so on can be a bit more of a challenge. But that being said, the dispute process as we go along has been, it actually has been relatively robust, and we're seeing new claims being issued. And new proceedings being commenced, and so on. And again, the overall issue here is that from a legal-based standpoint, in terms of the limitation periods, nothing has changed because of the COVID-19 crisis. So if you were required to file claims by a certain time, nobody's going to get a limitation defense on the basis that, I couldn't do it because of COVID-19. That's simply not going to work. It's also not going to be an excuse for not complying with court guidelines or court rules on filing of pleadings or anything of that nature. So our timelines pretty much haven't changed in terms of the courthouse. I don't have a slide for this next point, but what I do want to talk to you about is that, and Lisa, I think you sort of alluded to this in her comments, is that the COVID-19 issue is an interesting one from a force majeure or a unforeseen event standpoint, because it's now a foreseen event, right? If you're entering into contracts now going forward, it's no longer an unknown risk. In fact, it's probably the biggest risk facing a lot of construction projects out there nowadays. So to go forward and not have provisions in your contract that specifically contemplate COVID-19 interruptions would be would not be a good idea, because to simply fall back and rely upon unforeseen event provisions like 6.5.3 in the CCDC contract, or like clauses in other contracts, force majeure provisions, you probably won't fall under those elements anymore, because COVID-19 very much is something that people should be at the forefront of everybody's mind. So to that end, some government entities have developed their own provisions that they're dealing with already, and they're interesting in terms of the different approaches that they've taken. I'll just talk about two of them. The first is the City of Winnipeg's contract wording, which is relatively brief, but it does say that COVID-19 is something that the parties have turned their minds to, and the way that they've adjusted risk there, or the way they've allocated risk, largely falls on the contractor. the City of Winnipeg is willing to adjust schedule in terms of a COVID-19 incident. So if there was another outbreak and a shutdown that prevented people from working, they're willing to adjust schedule, but not provide any additional cost in terms of the delay cost. There is a small exception to that, and that is to say that if temporary works are required to protect the work during the period of a shutdown, so if something needs to be ported or something in the process of being built, needs some temporary protection around it, they'll pay for that temporary work or those temporary works to be constructed. But overall delay costs in terms of downtime, standby time, and other things of that, it appears that the City of Winnipeg is not willing to entertain under their COVID-19 condition. The other one is Manitoba Infrastructure and Transportation. They've come up with probably a more robust COVID condition in some of their contracts. Their position is that much more towards a pure force majeure provision is that neither party is liable to perform their contractual obligations. It doesn't relieve either party from their contractual obligations. It just suspends them for the time that the COVID-19 interruption occurs. And again, it's important to underscore the fact that it's only to the extent that performance is prevented or delayed. So if a portion of the project can't get done, but other portions of the project can proceed, it might be that there's one area of it where they can't honor social distancing guidelines or what have you, and they simply can't do that element of the project. You may have instances where a particular portion of the work can't proceed, and that may apply, that might trigger this COVID-19 language in the contract. But again, what we're talking about here is neither party is liable to perform. So what you would get there is you would get essentially a de facto extension of time for that work, because the contract obligations are suspended during that time, but you're not going to get additional cost payable by the owner to the contractor. The other element that the Manitoba Infrastructure and Transportation have built in, and this is sort of the reverse of the CCDC provision, is they've built in a provision that says if the suspension of work persists for 30 days consecutively, it allows the owner to terminate the work. So, under the CCDC provision, there is a language in the CCDC contract that allows that for the contractor, where if the work has been suspended by, act of a civil authority or so on, and that suspension lasts for more than 20 working days, then the contractor has the ability to terminate. In the Manitoba Infrastructure and Transportation contract, they've flipped that and given it to the owner. And not given the reciprocal right to the contractor. So those are a couple of approaches that a couple of government entities have taken to it. I think that the language of the City of Winnipeg wording, I think, is certainly available on their website. I'm not certain that the MIT one is, so, but it's likely available, I would imagine, for the WRHA if you were to ask for it, if you're looking at wording to put in there. So that's a couple of different approaches.
Yeah, so to your point, John, I think that addresses partially question number one. I put the questions up now on the screen. So the first one was about force majeure, and then how it works with the general conditions. So John, just to clarify, the wording, unless you prepared supplementals, the wording of the CCDC does not in itself contain what would be considered a true force majeure clause.
Yeah, I think it's more of a, I don't get lost on the actual terminology of it. The 6.5.3 is as close as you get to a force majeure clause with respect to the CCDC. But I think you're right. If you're talking about what's a pure sort of force majeure clause, they don't really have it. But 6.5.3 is as close as you're going to get.
So then, as John was saying, what City of Winnipeg MIT has done to address that going forward is to then include some new wording on the basis of what we understand now about COVID. So I think I'm going to move to the second question. So the question is, while force majeure can set the stage for termination, our desire may be to temporarily suspend or amend activities. Right. So, and I did say at the presentation that the Construction Association, the need to document the suspension of responsibilities. So termination versus suspension. So force majeure is not termination. So unless the contract provides that after X number of days, the contract can be terminated by either party or is terminated by either party. And then if there's an option, someone exercises it. Force majeure by itself, unless the words contemplate otherwise, does not terminate your contractual obligation. And so what you would need to do then is document an ongoing effort to resume your contractual obligations, because you may be asked for that down the road if the restrictions change. And as we know, things change quite often with this. If the restrictions change, now you're able to perform. The parties need to have an ongoing dialogue. So it's both sides. If you've been served the notice, you want to request ongoing evidence of the parties' attempts to unsuspend their obligations or attempt to fulfill their obligations. If you're on the side of the party who has exercised the force majeure clause, you'd want to continue to document your efforts to be able to perform and provide to the other side evidence. Again, that's not required by the force majeure clause, but if you work backwards from what we've seen in terms of problems that arise later, litigation that arises later, all of these things are steps that if you take them along the way, that would help you if there is a dispute afterward. Of course, if there's no dispute, if things work out well, the restrictions on COVID-19 are lifted, you're then able to perform your obligations and the contract resumes. Of course, that's like best case scenario. But what I'm talking about is evidence of mitigation for if down the road an issue arises about whether or not you were justified in your actions. Then the third question, if faced with justified impacts, projected ongoing monthly costs, etc., this is a construction question, what considerations and documentation can be used to mitigate, duplicate, or enhance costs? So how do you avoid cumulative damage? So John, did you have some advice in this regard?
Yeah, I think it starts off with if you do have the contractual language in place that deals with COVID-19 issues, this will be something you'll be able to deal with a little bit better. But if you don't, and you're currently in the issues of dealing with 6.5.3, what you're going to want is to keep a close monitor on what the mitigation steps are that are being taken. And so on. And you want to have that open channel of communication with your contractor, so you consider about, what truly is the mitigation element of it. And as the owner, you have the ability to direct a lot of that, a lot of what's going on with respect to that, and say that, we don't want you to demobilize. We want you to keep your equipment on site and so on, because it may be that, and this is where the owner, you get sort of the benefit, but also the burden of controlling some of the elements of it, because you may be able to say, look, we're prepared to pay you to stay on site, keep your rented equipment on site or what have you, so that we don't incur a demob and a remobilization cost that is associated with this, but we want to know what those numbers are. So certainly you can ask the contractors to run those numbers, ask them what the cost would be to keep the equipment on site versus demobilization, remobilization, and so on. I think it's just that open conversation that you need to have if there is an event that's a shutdown type of event. Ask for the information, because you certainly are entitled to it if a force majeure type claim or a claim for unforeseen events under 6.5.3 is being made.
And so that ties a bit into the next question too, about the contractor's obligation to mitigate impacts and be proactive in addressing issues. What are reasonable deliverables? Well, very simply here, one thing I can tell you that we've advised one of our clients and that they're doing on an ongoing basis, a contractor, is provide a weekly COVID report on each of their projects. So they would provide to the owners a weekly report, and it always continues from the week before, and explaining what they're doing. For example, adjustments to schedules to contemplate social distancing, delays, cumulative delays that are occurring because of some of the sanitizing, the cleaning that they have to do, keeping the not delays, like one of the projects that I know of when I was speaking to the contractor, they said there's no delay now on the entire project, but they just want to make sure that the owner knows on a weekly basis what could be leading to the delay down the road. Not much has changed in protocols in the last few weeks. So even though things haven't changed, you'd still want to be updating as to what you were doing so that if something arises later on, you can look back, the owner can look back and say, oh, they were doing that. Okay, well, that's the best they could have done then. And I'm just simplifying it, but I would say something like a weekly report seems to me to be the most reasonable thing. And with the contractor then indicating what they're doing to try to limit any potential damages going forward or any potential claims going forward. John, do you have anything to add about that?
Yeah, reasonable is going to be dictated by the circumstances and so on. So it's a little bit difficult to say that, you know, that this sort of category of response is going to be reasonable, because what's reasonable for a particular project might be something that's completely different from another. But, you know, again, keeping these open lines of communication right through from not only with your direct contractual reports, but key subtrades as well is important during this time. We've had, you know, some clients who have, and I'll just give you an example, you know, been working not only with their contractor, but with their steel fabricator and so on to ensure that during the slowdown that, you know, there's not significant carrying charges that are going to go forward, and then another delay on top of that to get fabrication started again and so on. The way that, you know, in this particular instance, it was being dealt with is that there was an agreement to, you know, go ahead and fabricate a certain amount of the steel that would be needed for the job, even though there was an understanding that in this particular case it couldn't be put up, and then it would be stored on site with a title agreement transferring it over to the owner and so on. So there are different things that can be done, and the reason why that was done is because they were facing a large carrying charge for the cost of the steel, plus a delay cost that was going to be built in if they were told just to stop completely. So there's different elements that can be done in different projects, and, you know, that may be, you know, the wrong thing to do on a different project. But the idea here is just to keep open those lines of communication with the contractors and see what is possible if there has been a slowdown or a stoppage of the work in particular areas, to talk about ways that that you can mitigate that, work around it, so that that you're not facing a delay out of the gate when you start back up again. So those sorts of things, again, it's the open lines of communication that are key.
Great. So the next question again deals with a specific construction scenario. What it says is one of the characteristics of most of our projects, the place of work is typically within or surrounded by space occupied, controlled by the owners. And the contractor is responsible to provide a work plan to address the changes. What responsibility do the owners have to assist or facilitate in this? And that's a great question, because rarely is a construction project of the type that you'd be undertaking as well done just in a vacuum. There are other people, other occupiers of the space, owners. So John, what would you say in response to this?
Yeah, I think in those sorts of scenarios, I think it's a difficult question. Like, it's difficult to say that it wouldn't be your cost if the contractor is willing to come in and do certain things, but you can't accommodate them in those situations. In that scenario, I think under a classic CCDC type provision, that's going to fall back on the owner. Like if the contractor has said, look, we're able to do this, 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 and this, and you know, they comply with government regulations overall, but they don't necessarily comply with your site regulations. You know, a lot of that will fall back on the owner, unless you can point to something in the contract that says, you know, that you can hang your hat on something, and there might be something in your safety policies or something of that nature where, you know, you have to, you know, perhaps the contractor has signed an agreement to adhere to all safety directions on site and so on, and with an acknowledgement that these may change from time to time and so on. There might be something you can hang your hat on there. But generally, if they're willing to come back and do things that, you know, they can social distance, they can work staggered shifts or what have you, but you can't accommodate that, that's largely going to fall on you. Mm-hmm. So that's something that's something you'll need to plan for as you go ahead in terms of your contracts going forward. you may want to write that specifically in your supplemental conditions to say, look, there may be situations in which we have to direct you not to work on site, and you won't be entitled to additional costs for that.
Well, that also comes down to a bit of negotiation. So, for example, our actual premises, our law premises, we're doing renovations. Of course, we're doing renovations during COVID. It's great. One of the contractor came to us early on when this first started and said they wanted to extend their shifts. So they would work longer shifts, but then less people on the job site. Well, one of the issues is then with the elevator and the building security. So what we did then is we went and talked to the building security, and they gave us permission to have our contractors do that. But part of it was just negotiation and talking to them. Now, if our building security had said, no, we're not letting your contractors be in the in the space at all hours of the night, that would be a different discussion. But then perhaps there's something under our lease that we could have looked at to say, no, you approved the work, and it doesn't say here that they're at our risk. We have them insured; they should be able to be here. I'm just using that as an example of you do sometimes in these situations you have to go, as John said, keep everybody informed. Go talk to the other parties and see what type of solution you can come up with. I think what I'm going to do now is I'm going to unmute everybody, and then we have 15 minutes for questions. I've never done this before, so let me see. I'm just going to see how, there is a way I know where I can unmute everybody. I think here, hang on. Okay, I thought I had unmuted everybody, but I think I just unmuted myself. Let's see, unmute all participants. Unmute all attendees, yes. This is what I'm trying to do. Apparently it's not letting me. All right, maybe I can just unmute people individually. Let's see. There we go. People are all coming unmuted now. There we go. So what I would say is, if you have a question, leave yourself unmuted. If you don't foresee yourself asking a question, then just go ahead and manually mute yourself so we have less feedback on the line. And we're happy to take questions. No questions? There's got to be at least one.
Lisa, can you hear me?
Yes, there we go.
Okay, I do have one question. So if
Sure.
there's extended hours of operation, so the contractors begin to work 2 shifts or anything like that, would we be liable for overtime costs? Would they be able to charge us overtime for that because now they're working additional shifts in order to get physical distancing?
See, based on the work I've done, again, it's very limited. It's only been in the last 6 weeks. I've dealt with two clients on this. It didn't end up being overtime because it was the same amount of hours, just different hours of the day. So they didn't want to. We didn't even get into the overtime issue because they wanted to keep the hour. So it was. I think they were going from 6-hour shifts to 8-hour shifts, but the number of hours in the week was still the same. So there was no overtime based on that.
Okay, thank you.
But that is a good question though, because in some projects it might make more sense due to the unknown of what could happen maybe to your supply chain moving forward. You might want to just get the work done faster. Then I think you would rightly have to pay for the overtime. But having said that, it might be made up for the fact that the work would be done in a shorter time period.
Yeah, I think it depends on whether the deadline for the work gets extended or not. Sometimes the work can't be extended because there's a fixed reason why it has to stay at a particular date. And in order to accommodate that, they may have to either throw more guys at it or do double shifts or something. So,
correct. Yes. Greg, I see you're unmuted. Do you have a question?
Well, it's in line with what Sheila was asking. It's just like most of the projects that we're dealing with represent the concern, like the current ongoing work represents the concern, where contractors are coming back indicating that they've got costs. So there's been lots of suggestion to engage in discussion with people, but ultimately we're bound by the contract. So we can be accommodating to try and maintain a relationship, but we're finding that we're fast getting up against a wall where the costs being presented aren't reasonable. And that's the problem we're facing. How to negotiate through that, and for argument's sake, superintendent cost without a projected re-engagement time, contractors are suggesting we carry the full value of the superintendent's monthly cost to ensure that that resource is in place. There's no demonstration of any sort of service in return for that fee, so it doesn't seem reasonable. So I know a lot of it comes back to the owners just having to make a decision, but it quickly gets into this gray area. It's not based on the contract, it's goodwill and talking to people. That's all it is.
Mm-hmm. John, do you have any suggestions?
Well, I guess for future contracts, like how do we reinforce our wording so we don't have to negotiate?
Thank you.
Sorry, there we go. John had to hold up the sign. Great, now I've unmuted you. Sorry.
All right. Sorry about that. Yeah, Greg, the issue of the unreasonableness, I think, again, you're not going to find a contractual provision that will force people to be reasonable. Everybody should have to be, and so on. And when you get into a dispute, that's where the sort of issues come to the forefront. I think the best you can do in terms of the negotiations on that are point out the holes in their argument and say, well, look, for your supervisory costs or superintendent costs, you could have done it this way, or you could have done it that way, in order to mitigate it. And these are steps that you failed to take, because one of the things that we're seeing continually in the literature around the force majeure clauses and the delay clauses like this is that parties aren't entitled to just throw up their hands and say, well, it's COVID-19, so what could we do? As long as you have an answer to that question of what could we do, you could say, well, you could have done this. That really, should put people back or cause people to, pause and say, yeah, maybe I should have done that in retrospect. So I think as an owner, the position that you're in when you're in these negotiations is to think about, put yourself in the contractor's shoes a little bit and say, okay, well, what could they have done for us to mitigate some of these charges that they're now coming back with, and so on. And to the extent that you can get ahead of it, when you do have a delay, so if you have experienced claims of delays from a contractor on COVID-19 issue related delays so far, to the extent you can't fight them back on these ones, make a note of what's happening this time around so that you're prepared for it next time around, so that when you're given notice of a COVID-19 issue next time, if there's something that you didn't like from this go around, you're able to go back to them upon receipt of that COVID-19 issue and say, okay, well, we better not see additional supervisory charges for this, and this, because we expect that you're not going to run them this time. And direct, because that is the one thing that the owner does have a good handle on these sorts of things, is when those notices are provided, there is a significant amount of leeway for the owner to provide direction.
Anyone else?
What about the issue if there's a dispute as far as what's considered to be a safe work site. So let's say we've engaged some mitigation strategies, provided masks or PPE or such things to the contractors, but the contractors are still claiming that they feel unsafe to either enter the site or to perform some of the work. And there's a question of how do you define safe for people? Do they have the right to not attend the site if they don't feel safe in their opinion?
I think that it has to be based on some sort of objective criteria as to why they don't feel safe. If they're simply saying that, look, I can't come work on a hospital site because there's a pandemic right now and I don't want to be anywhere near a hospital, I don't think that cuts it, particularly when steps have been taken to assure them of their safety, whether it's PPE or social distancing protocols or whatever has been put into place. It'd be a little bit different, I think, in Manitoba if we were dealing with, the level of outbreak that they saw in New York City in a hospital ward where people were coming in hourly with suspected COVID-19 cases, and you're supposed to be working on the doors of the emergency ward. That's something that would be a little bit more believable. But if somebody's simply saying that I don't want to work in a hospital setting right now or in a healthcare setting right now because of I just don't think that cuts it. There has to be something objective that underlies that. It can't just be, I don't feel safe, particularly when there's all sorts of protections that are out there.
So I'm just looking at another presentation. I'm not sure if you, any of you were at it. One of our partners did a presentation at the Construction Association a few days before John and mine, and she spoke specifically about workplace safety issues. And okay, so under the Workplace Safety and Health Act, a worker has a right to refuse work if he or she reasonably believes it's a danger to his or her health, but there are definitions. So in order for something to be considered dangerous, it has to be unusual to normal working conditions. It has to result in, likely result in serious illness. And the employer has not put reasonable controls in place to eliminate the risk. Then there's a whole list of what's reasonable. And of course, right now for COVID, there's so many provincial guidelines that have been published. So the idea is, if no one's supposed to be reinventing the wheel here. In fact, I would say it's the opposite. You're supposed to be implementing the guidelines that the department has put in place. So what her presentation said was that you're still permitted to refuse. So of course it wouldn't be the refusal. Let's say I'm breaking this down a little. It wouldn't be the contractor telling you, I'm refusing to come. What's happened is their workers or whomever have told them they're not able to come. So then of course they tell you. So there is a process under the Workplace Safety and Health Act for a person to refuse to come to work. And there's a process where they report to their supervisor why they won't. Then there's a process that has to be resolved. And right now the Workplace Safety and Health Division can be contacted for, I don't want to say like a mediation, but to hear it. And they're apparently fast tracking these. So they're having them dealt with in a very expeditious way so that people can then either return to the workplace or the employer knows that they are not able to return. Having said that, there are, as John was saying, there are objective guidelines as to what is considered hazardous or dangerous. And if the employer has put in place the measures for taking the precautions, that is what is considered then your due diligence in terms of negating an ability for a worker to then say it's unsafe.
But I still think that there's a distinction to be drawn between that system and a contractor saying that my employee won't show up. If a contractor says my employees won't show up and therefore I can't honor my contract, that is a different aspect of it. And I think you're still entitled to say to the contractor, we're providing a safe work area. We expect you to come. You as the contractor, you're expected to manage your staff appropriately, train your staff appropriately, and you've represented in your contract that you have sufficiently trained and available staff to do this work. So if we've provided a safe workplace for you that meets the criteria of the workplace health and safety rules, you should have to come to site and do it. And I don't think that the fact that a contractor is having trouble with one of its employees or several of its employees would relieve them under the provisions of a CPDC contract and so on. That really becomes the contractor's problem if their employees aren't going to come to work. So I think under, in terms of the contractual relationship between yourself and the contractor, that may be an issue that they're facing. And depending on the circumstances, I'm not saying that you always take a hard line on it. You may want to grant some sort of relief there, but I don't think that you're contractually obliged to.
So I note that we have about 1 minute left. We don't want to keep you past the time that we had scheduled. Thanks to all of you for participating. I told Denis that we would send in the slides. If you have any follow-up questions, or if in preparing any of your contractual documents going forward to contemplate COVID, you have any questions, feel free to contact us and we can help you out. And if, as I said, if you have any other questions after this, definitely let us know. John, are you going to come back on? There you are.
Thanks,
all right,
everybody.
Thanks, everybody. Bye.
Bye.
Thank you.